All right. Good afternoon, everyone. Thank you for joining us for another GovCon 101. Today we have two expert instructors joining us from Wiley. That is Scott Felder and Craig Smith. They will be covering data rights over the next 75 minutes. Over the next 75 minutes, the show will be theirs. I'll handle some things in the background. So if you have any questions regarding anything PCI, so passwords, certificates, anything like that, please let me know in the chat. If you notice any audio video issues, please let us know in the chat, such as the slides aren't advancing. If you can't hear Craig or Scott, but you see that their mouth is moving on camera, anything like that, please let us know so we can get that all squared away. Additionally, if you have any questions for our instructors, you can put that into the chat as well so that they can answer those throughout today's training. We're going to have a couple of passwords for today's session. So we're going to have one near the middle and near the very end. You'll see those pop up on your screen, and it's going to pop up just like this poll is popping up for you now. So please just take a second to answer this poll. This is how the password's going to pop up. For this poll, you can answer it directly there. For the password polls, you're going to want to write those passwords down somewhere that you remember so that you can receive credit for attending today's session. So I'll leave this up for just 10 seconds or so, and then I'm going to hand it off to Scott. All right, Scott, it's all yours.
Great. Thanks, Josh, and welcome everyone. We're going to spend the next hour plus talking about data rights. We've got a companion piece coming up in a couple weeks dealing with patent rights in the government contract space. Today's focus will be on the other side of the equation. The regulations do draw a pretty hard line between rights and data and the government's rights in a contractor's patents and inventions. So half of it today, half of it in a few weeks. Next slide, please. What we'll discuss today, we'll start by taking a look at how the United States government bargains for intellectual property, go over some key concepts and fundamental principles. The idea there is if we give you sort of the foundation here, if you forget the specific rules that we'll talk about and you're looking at a solicitation or you're putting together a proposal, by understanding sort of the first principles, it'll get you part of the way, perhaps pretty close to all of the way, to where the regulations would have you end up. We'll share with you a framework for analyzing intellectual property issues in the government marketplace. Then we'll talk about how the government acquires data deliverables and how the government acquires data rights. And we'll discuss what the difference is between data deliverables and data rights. And then we'll close out today by taking a look at how a contractor... Sorry, Josh.
Yeah, sorry, I was gonna I wanted to pause you just for 1 second. So as you could probably see, people are joining now. The wrong link was sent out to attendees earlier. So we may just want to start from the top in a few seconds or so. I'm sorry about that.
No, that's fine. No, don't worry.
You'll see it's kind of flooding a little bit now, which is starting to make sense. All right, so I'll just give another brief intro again. My name is Josh. I'll handle any of the background information for you if you have any questions for PCI. If you notice any audio issues, please put that information into the chat so we can get you all squared away. Our two expert instructors today are Scott Felder and Craig Smith. They are joining us from Wiley, and they will be running the show for the next 75 minutes. So we're going to be going from 1 p.m. Eastern until 2:15 p.m. Eastern. Scott, the floor is yours again. Sorry to cut you off before.
Yep, no worries. Take two, maybe even better than the last time. So Craig and I are going to present today on data rights in the government marketplace. We've got a companion presentation coming up in a few weeks on the government's rights in a contractor's inventions and patents. Between these two 101 sessions, it should give you a pretty good overview of how the government acquires rights in a contractor's intellectual property, whatever the form of that IP might be. Next slide, please. So we'll start today by looking at how the government bargains for intellectual property. We'll begin by giving you some key concepts and fundamental principles. The idea here is that if you understand the basic underlying framework for the rule sets, even if you don't remember a specific rule, and we will go over the specific rules, understanding the first principles will help get you most of the way to a solution. We'll share with you a framework that we use to analyze intellectual property issues in the government marketplace. And then we'll take a look at how the government acquires data deliverables, how the government acquires data rights, and what the difference is between those two concepts. And then we'll close out today's session by looking at how a contractor protect its intellectual property in the federal marketplace. The restrictions we talk about, the rules that we talk about are not self-executing. So there is a process a contractor needs to go through if it wants the restrictions to attach. And that's what we'll look at to close today's session. Next slide, please. Actually, let's go 2 slides. So the federal marketplace is a unique marketplace. You often think about, the government, when it bargains commercially, it behaves like any other commercial purchaser unless it's otherwise regulated. The FAR and its various supplements are, of course, fairly extensive collections of otherwise regulated. And then if you're talking about non-commercial or other than commercial acquisitions, certainly you're stuck within the rule set that the FAR and its supplements prescribe. And it's important for the contractor moving into that marketplace to understand the various rule sets that apply to various forms of intellectual property if it wants to protect that intellectual property. And the considerations for protecting intellectual property in the federal marketplace are not dissimilar from what the considerations would be of why you would want to protect your intellectual property outside of the federal marketplace. For example, you want to protect your market share. You want to be able to sell to the government. You don't want your competitors to be able to sell competing products or services to the government. You want to protect your competitive advantage. If you've invested a lot of money in research and development and coming up with cool new widgets, you don't want your competitors to be able to leverage your investment for their own benefit. And the flip side of basically that same coin is that you want to make sure that the rules are set up in a way that contractors are willing to make that investment in technology that it's going to offer in the federal marketplace. Because if you don't create that right incentive structure, then contractors will not devote their best and their brightest and their intellectual capital to developing products and services for the government. They will turn their attention elsewhere, and the government and the warfighter and so forth will not enjoy sort of being at the cutting edge in the way that we really want our warfighters and our government employees to be. Today's focus and the focus of our session on patents are going to be on the rule set for FAR-based procurement contracts. So we're going to be talking about a very specific context and a very specific paradigm or very specific rule set in today's session. And a lot of the other rules, a lot of the other contexts can be understood by extension or by analogy or by exception to what we talk about today. And in fact, the rules that we're going to talk about today are very often the starting point for other instruments, such as other transaction agreements. So if you know anything about an OTA, you'll know that there are essentially 0 IP rules, no statutes, no regulations that apply to the IP terms in an OTA, but you will very often find that they start with the rules that we talk about today. Just because we're talking about a specific rule set, a specific context today, doesn't mean that outside of that context, nothing's protectable, or outside of that context, there are no rules for it. I just want to make sure everyone is sort of level set on here. We are talking about a very, very specific context today and a very, very specific set of rules. Outside of that context, you may need to be adapting a little bit. And an important thing to remember here is that if you don't follow the applicable rules, indeed, if you don't remember or don't think about those rules when you're planning or developing a product or a proposal, you are potentially putting your ability to protect your intellectual property at risk, certainly vis-a-vis the United States government, and potentially with respect to your competitors as well. So you could be undermining your own ability to protect your market share and protect your competitive advantage, undermining your ability to recover any investment you have made in technology development if you are not thinking about, conscious of the rules, not just when you're performing your contract, but also when you're innovating and when you're putting together a proposal. Next slide. I want to spend a little bit of time talking about what you can expect of your customer in this context. So what can you expect your government counterparts to do? Number one is that you can expect the government to deliberately plan for both data deliverables and data rights. What's the difference? Data deliverables are stuff. So just like the government might say, we want 50 computers or we want 50 armored vehicles, the government can say, we want 10 copies of your source code on CDs, or we want 15 different engineering drawings. Those are data deliverables. It's content. It's an element of contract performance. Data rights are what the government can do with those data deliverables. So, for example, can they disclose your source code to a competitor and allow a competitor to make modifications to it? Can they make additional copies of your engineering drawings? Can they use your engineering drawings to create additional end items of whatever it is that's represented in those engineering drawings? Those are rights. The two go hand in hand. Having data rights is no good without data deliverables. If you don't have the deliverables, you cannot meaningfully exercise the rights. If you have a pile of deliverables with no rights, you can't make any meaningful use of those deliverables. From a deliverables standpoint, the government can order essentially whatever it wants. There is no statutory or regulatory limit on what the government can ask for you to provide as an element of contract performance. You're not obligated to accept a contract that requires you to deliver certain things, but you can't point to a statute and say, okay, that statute over there says you can't even ask me for that type of engineering drawing. Nope, they can ask for whatever you want. You can price it. It's a negotiation. On the rights side, however, there are some statutory and regulatory limits on what the government can ask for. Number one, the government cannot demand that you surrender rights that you are entitled to restrict as a condition of award or responsiveness. So, for example, if you have something where you are justified in asserting limited rights, the government cannot say, you know what, we're going to throw you out of the competitive range unless you give us at least government purpose rights. That is illegal. The government also can't discourage a contractor from submitting a rights-restricted solution. So, in other words, it can't structure a procurement in a way that says that disadvantages you if you offer up limited rights instead of government purpose rights or unlimited rights. Now, that has an interesting interplay with the third bullet, which is the government quite clearly can, and more often does, evaluate a contractor's willingness to deliver and or license its intellectual property more broadly as an evaluation factor during the source selection process. And it's not entirely clear to me, I'm not sure it's entirely clear to anybody, where the line is between a permissible evaluation factor that looks at what rights you're willing to grant the government and perhaps gives you a credit on your total evaluated price or your total evaluated cost based on the number of things, additional things that you enable the government to do with the license that you're proposing to them, and actively discouraging, which would be illegal, the contractor from proposing a more restricted solution. But that line is there someplace, even if I don't know quite where it is. The next thing you can expect your customer to do is put an emphasis on modular open systems approaches, MOSA, and the A changes. Sometimes it's approaches, sometimes it's architecture. Right now it's approaches. This is essentially a way the government can avoid having a contractor's intellectual property lead to vendor lock by treating certain aspects of a procurement as a black box, where the government doesn't need to know what's going on inside the black box, which might be something that the contractor holds very dear, but simply instead specifies form, fit, and function about the black box, what inputs does it take, what outputs does it provide, what physical characteristics does it possess to fit in a particular vehicle or particular environment, allowing them later on to, without access to the contractor's intellectual property, pull out the entire old black box and replace it with a brand new black box that perhaps reflects more modern technology or more upgraded functions. And then the last thing I think you can expect of your customer is that they will go through the validation and challenge process to test restrictive assertions that contractors make where they believe they have a reasonable basis to do so, and parenthetically, sometimes when perhaps they don't. I think that the government is very conscious of the amount of money that it has spent on contractor activities that touch technical data and computer software, and may therefore believe that they are entitled to broader rights than the contractor has initially granted or asserted. We'll go through some of the questions that sort of inform that analysis. For example, is the thing the government paid for actually development, or is it something else? So I do think the government, in sort of inventorying what it has in terms of data and data rights, is becoming a bit more forward in making challenges to restrictions that are advanced by contractors. Next slide.
I think this is me.
I think it is.
All right. Well, hello, everyone. And I think a couple of key concepts. Scott mentioned at the very beginning that keeping rights and data and then rights and inventions and patents separately. And so there'll be a second follow-up session to this on patents. I'm sure they'll talk about March-in rights in the news. We don't have anything quite as exciting for technical data rights next to talk about today. And then you'll see these kind of terms, and I would just want to keep incanting them. Scott had mentioned we're looking at procurement contracts, FAR-based, DFARS-based, but technical data and computer software, and then the deliverables of both. And those, especially in the DFARS, are like the terms to just keep bearing in mind. You'll often hear the term data rights, and I think when used casually, you should think of it as encompassing technical data and computer software, but understanding we're going to talk about those two terms having kind of specific defined meanings that are important to understand, that these are terms that I'm going to be expected to kind of know and use and see a lot in the regulations, contract clauses, protest decisions, and so on. There's other ways to protect information or that is protectable, and there are other rules that we're not going to get into in the time we have today. And then the other thing is, Scott had mentioned we're going to talk a lot about restrictions on what the government can do with technical data and computer software. It's also important to bear in mind that regime sits alongside other types of regimes like classification markings or distribution statements and similar CUI markings. And so sometimes you'll end up, if any of you who have looked at them before, sometimes deliverables to the government have enough markings on them to look like a stock car from NASCAR or something. This is just one piece of it. The other is, as Scott said, I just want to reemphasize, these clauses allocate the rights. They don't tell you what the deliverable is. And I've been part of, I know Scott's been a part of conversations, well, I'm entitled to unlimited rights in that. Well, if you had a deliverable line item for it, maybe you would, but you don't. And so I'm keeping those two concepts as distinct. I've heard Scott use the term inchoate rights before. We may touch on that a little bit later. It's a great way to think about it. And then the other thing that is important to bear in mind is these rights, the regime really is focused on the relationship between the government and the prime contractor. But as the last entry on the slide says, they very often will inform what the rights and responsibilities are in terms of rights and intellectual property between a prime and a sub, or a lower tier sub and a higher tier subcontractor. You'll oftentimes see FAR clauses, and we'll talk about it a bit more on a future slide, in flowdowns, and trying to unpack how those relate to, say, intellectual property clauses in general subcontract T's and C's. It can take some education depending on how familiar your counterparty in a prime sub or similar negotiation is with the regime at the federal, at the prime level, and then how it may or may not apply to what it is you're actually subcontracting for. The next concept is, I think, another one that when I started getting interested in this aspect of federal contracting, I'll confess it took me a while to fully wrap my head around it. But I think once you get it, you kind of, it's like being on the other side of the bridge where you can't imagine another way of understanding the world. And so the idea of ownership versus license. When it comes to technical data and computer software, the government rarely, in a FAR procurement scheme, takes actual ownership. The litigation, the negotiations, the competitions, they're over the rights that the government gets as a licensee. You're probably familiar with other forms of licensed intellectual property. Some may be very limited. Some can be, in essence, a very, very broad worldwide free licenses. You can think about the license that your family photographer gives you to produce or print photographs of your family under copyright. So here, the government, it's the same thing. They don't own the technical data. They don't own the computer software in most cases, but they do have what are often pretty broad rights when they do have them, or even limited rights, much more limited or restricted rights to use and disclose and otherwise make use of. The other is, and this is one area where I think it speaks to something Scott said a moment ago, which is you see that take the minimum necessary, no grabs. And the idea is that a government agency, if they need GPR for their legitimate business needs, they shouldn't be asking for unlimited rights. If they need restricted rights, that's going to satisfy them. They shouldn't be asking for GPR. Take the minimum rights that you need. But as the middle kind of sub-entry there says, the sub-bullet, what's the minimum? That's an area where it really does get down really into the particulars. And the government is aggressive about what deliverables they want, what rights they want. I'd say it's important to remember that the aggression kind of comes in two forms too. And understanding when you're dealing with a counterparty, which of these you're facing can really help with just trying to get to the right solution for yourself and your client. One scenario is someone's just aggressive. I'm going to take what I can take. The other, which we encounter with some frequency, is I'm not exactly sure what it is I need, and I don't want to get caught short at some point in the future. And so it ends up becoming aggression driven by risk aversion. And those are times where if you really understand not just what the regime is, but what the business case is, what's the product or service, what's being delivered, what are the future market opportunities, I think having that kind of conversation can often help you get to a better place than just sort of throwing terms at each other back and forth like a more commercial, numbers-driven negotiation. I don't want to give anyone the illusion that this is easy to do, that you can just pick up the phone and have that conversation, and within an hour, you've got a special license all worked out. But I think bearing in mind that many times it's, I need it because I don't know what I need in the future. I don't know how I'm going to use this in the future. And that can be very difficult to kind of make progress with unless you try to help someone unpack that. It's also hard to internally make the business case. What are the pros and cons of giving this, unlimited rights license versus negotiating at GPR that we think we have? What about pricing it? What are the future competition opportunities? So really think through that. We talked about you need both deliverables and rights for the government to get what it needs. And we did talk about no conditions on responsiveness for awards. So as Scott said, they can't force you, but they can strongly encourage you. There was, you'll see sometimes special H clauses in procurements. Folks may remember the replacement for the UH-1 helicopter. There was quite a lengthy protest at GAO about 5 years ago about an H clause that in some ways on its face may have purported to take more rights than statutorily authorized, others that were a little more flexible. More recently, we've seen what you might think of as a kind of priced value. Scott mentioned that a moment ago. And it's, okay, what is, in almost a commercial sense, the value of one set of rights we might be given from offeror A from the rights we might get from offeror B? And, again, under the circumstances, that could feel more coercive. Other times, it might feel a little bit more like, hey, companies have differing solutions, particularly in the commercial marketplace, and it may make sense to see what it is they'll offer and try to be more like a commercial buyer and see what kind of rights that we're able to get our hands on and what the value is of that. In one of the protests I looked at, though, the kind of the value that the government assigned to the rights and the way they were factored into the competition ended up being something like 10% of the delta between the actual two offerors. So we don't have a sense of what does it look like in the end game in that procurement if there's ever a challenge at GAO about, I think my IP was not valued effectively or rationally in this competition. So let's refresh. We are, about a third of the way into today's session, and these are ones that you can do over the space of kind of a day, 2 days. So what's our framework? We talked about like how do we want to go in this and make this kind of a linear process. And we talked about, again, first is what is my situation here? Is it a FAR-based procurement contract at the prime level? Am I dealing with a subcontracted under a FAR procurement prime contract? Is this a grant or a cooperative agreement? Those have different kinds of clauses compared to FAR procurement contracts. Is it an OTA? And often, as Scott mentioned, you have something of a clean sheet to work with when it comes to what are the IP rights or the data rights in an OTA. But often you'll find, well, if I have a blank sheet, where do I look to? I look to the existing FAR or DFARS regime and apply that here because it's familiar, I know what it is, and I don't have to make up something new. And especially if you go back to the risk aversion I mentioned ago, going with something I know, I understand how the regime works, and I'm comfortable with it. Sometimes, I mean, that's how we end up with OTAs that oftentimes that you might be hard pressed to distinguish them from FAR-based procurement contracts. The other thing is, what's the next question? And this is a really, you know, we've said this several times, but this question I find is really critical when dealing with the business that you're advising, because I often find this question gets kind of blurred an awful lot. Are we talking about what do I have to give the government, as Scott said, versus what rights does the government have to give once I've delivered it? So really take the time to understand when you're being asked to give advice, or you're trying to formulate a negotiation position, what are we talking about? And then if it's the rights, again, data rights or patent rights. Most of the time, you're going to kind of know pretty readily, which is this. The two areas where I think you might want to really be attuned to what am I being asked about or what am I negotiating over. One is when you're looking at FAR flow downs or equivalents. The patent and the data rights clauses sit right next to each other. And so making sure you understand what are we talking about here? Is this a patent clause or a data rights clause? Over time, that'll become very intuitive. The other is thinking about, I find in particular subcontracts, or, the way that the FAR clauses can sometimes intersect or interact with general IP clauses. So works for hire that you may be asked to negotiate over, retained rights. Sometimes primes will just simply ask for whatever license we need to fulfill our data rights at the prime level with the US government, in which case you need to understand what rights you may be giving up in that circumstance as if you were a prime contractor. That's very different from trying to deal with patents. So understanding where you're looking at. But of course, we know today, as we've said several times, we are talking about data rights. And so here's my next set of questions for you. Who's the customer? And that really matters. And I'll tell you a story about how I got interested in this. Is it DoD or a civilian agency? And the reason that that's really important is they are different, and as you'll kind of come to initially appreciate today, almost irreconcilable regimes for how the rights are allocated and the way that the analysis is done. And so I ran into this, and you may see it too, so I want to highlight it for you, where I would be negotiating flow downs, and my counterpart, usually for a subcontractor, and the prime contractor would flow down both FAR and DFARS data rights clauses, when it was clearly a procurement for one, either a DoD, the Air Force or FEMA. It wasn't both, so it didn't make sense. And there would be times where I just pointed out, hey, we need to update or streamline this set of FAR flow downs, and I'd explain why. We'd move on quickly. Other times we got really, really bogged down in the, again, that risk aversion. I'd rather flow down all the FAR clauses and DFAR clauses rather than just some, because I can't get blamed for not flowing something down in that circumstance. But then you end up with, if there's a dispute, what are the actual rights in that circumstance? What rights are you kind of accepting that you're going to have to give up to the government by way of a flow down, or, that kind of is modified for a subcontractor? And, also how do those flow downs interact with any general IP terms in the body of the subcontract? So really understanding who's the ultimate customer when a subcontract comes across your desk, I think is a question that takes some time to understand the need to ask it, but it's a really important one. The other, what is the acquisition? Is it a commercial product or service, or is it non-commercial? Different regimes and rights there. In some ways it's simpler. In some ways, I think it depends on who the buyer is, whether it's simpler. And then, as we mentioned, is it technical data or is it computer software? There's different terminology. There's very slightly different rights between the two. Most people will, if you blend the two early on, people will generally follow, but it's important to start getting them right over time, especially if, say, you've got to negotiate a settlement agreement or negotiate a term. You want to make sure that you're looking at the right paragraph or the right set of rights when you get there. And this is very DoD specific, but still important to understand in general, who paid for the development? Where did the funding come from? Was it entirely at private expense? Was it through a U.S. government expense? And that question is not as easy as it may sound to answer. Or was it a mix? And so this is where at the very end today, we're going to talk a lot about record keeping. And this is an area where the quality of records you have around development funding, if you're in the DoD, the defense space, can pay off down the road or make your life kind of challenging if there is a challenge to a data rights assertion. So quickly, let's think about these deliverables. Two categories, one being technical data, and it's recorded information, regardless of form or method of recording, of a scientific or technical nature. It's a mouthful, but over time, you're going to get used to saying it. Recorded, of course, as you can imagine in this day and age, doesn't mean it's recorded on physical hard copy paper. Doesn't even necessarily mean it's recorded in what you think of as a document or we have a spreadsheet. There's a wide variety of technical data out there. It does need to be scientific or technical in nature, and you can see some of the very clear carve out there. Contract administration data. It's recorded information, and financial or management information may have a scientific or technical bent to it, but that is distinct. Cost data, pricing information, or the end item itself, what it is you're delivering. The Raytheon case that's cited there from a couple of years, I think about 3.5 years ago at this point, I think illustrates how sometimes it's very easy to understand. Oh, I've got the manuals and the engineering logs for this particular fighter jet, technical data. I've got the invoices for the engineering for that fighter jet, cost or pricing data. But what Raytheon involved was an Army contract where the Army asserted it had, there were non-conforming markings and it had rights in, unlimited rights in vendor lists. Raytheon had to deliver vendor lists. And you might go, that seems proprietary to me. Well, that's what the marking was. And that's because Raytheon considered the information proprietary. As you'll see toward the end, when we touch on markings, that's not a standard marking. And so the Army said, can't do that, need to strike it. And it became a whole dispute. Now I'm going to pause here and say, you might go, who gives vendor lists to their customer? Like that seems like when it says proprietary, we mean we don't want to give this out. It's one thing to put it into a prime contract proposal. It's one thing to put an invoice in that has sub costs, but to have the actual vendor list, it was a contract requirement. The Raytheon agreed to it via modification. So when Scott said earlier that what you have to deliver, there's often pretty free range, and it may not be something you're used to. And that's why understanding the rights you'll be giving and what you're delivering is really important. Or if it's something even subject to this regime in the first place, because that's what the court concluded here, that these vendor lists weren't technical data. It wasn't the actual engineering technical, how to actually make the end item work. It was more of a managerial or financial type information, contract administration. And so the conclusion was we don't need to go through the rest of the technical rights regime, data rights regime. The markings are what they are. Computer software. This is another concept that takes, I think, folks who are new to this space kind of a little bit of time to wrap their heads around, but once you do, again, it's hard to go back. So computer software, it's more than just Microsoft Word. It's more than just some ArcGIS. It's more than the programs that are running. You can see that list there. Computer programs, source code listings, processes, algorithms. And so, Scott and I have both dealt with myriad cases that have involved what we would think of as maybe documents, but they're PDFs, they are PowerPoints, but they can fit into this definition of computer software if it wouldn't allow the software to be reproduced, recreated, and recompiled. That is kind of distinct. In a lot of that, you think, oh, that's computer software documentation. But you can see the documentation here. I try to think of it in my own head as this is more almost like what a commercial outside user would get, owner's manual, user manual, kind of the final, here's how you use it. Much more limited scope. And so making sure that the business understands what what's computer program, what's a computer what meets the definition of computer software versus what's just documentation or a database, and how they interact with each other can be really important for what clause are you looking at for the rights, and also what markings do I need to apply, or do I need to apply markings at all for if it's, again, not computer software or computer software documentation. So it's not all code or finished products, finished operational software products. That is something to just take from this, and you'll find yourself well on your way to understanding this. And then the last question I have here is, okay, what's the contract say? This is really important. And you'll often get the question about what are our rights before you have what the materials are, or what was required to be delivered, or what clauses have we actually agreed to. I think this framework that you see here progressing logically. Start with what the statement of work or the PWS or similar description of the work, start there. And I think the reason there is understanding what is actually happening in the contract, what you're doing, will then inform the next two steps, which is to look at it's called a CDRL, a contract data requirements list, which can be like it's a length. Here are the things that you're going to deliver. Oftentimes there could be a when or frequency. And then oftentimes you may see what rights is the government taking you might see it worked in there. Sometimes it'll be in a different spot that we'll talk about and show you a little bit later on. And then there can often be a DID, as it's called, data item description. And think of that as a really helpful way to track what it is you're delivering. Some of you may get contracts where there's a report or a deliverable, a piece of software. Other folks are working on multi-year, multi-platform, highly complex software engineering projects where you've got to know exactly what deliverable you're talking about and have very sophisticated naming and numbering conventions to make sure of it. So I think to transition from here's kind of the framework for what it is these different licenses might apply to the types of licenses, I believe I hand it back to Scott.
You do, and it would be very helpful if I unmuted before that point. So as Craig said, let's turn our attention now to what the rights are that the government gets. And we generally divide this up into, oh, yeah, Josh, you want to do your first password?
Yes, sir. Sorry, I didn't want to interrupt.
That's okay.
Right after you started there, so I apologize for that. Well, let's do our first password. So for everyone, not sure if you joined after I mentioned this. I'm sure you joined a PCI program before. For GovCon 101s, we usually don't have passwords. For this one, we will. Our first one is up now. As a reminder, just make sure you write it down. That'll be how you receive credit for joining this training today. It's capital COWBOYS. Make sure you write down the passwords you see today. Leave it up for about 10 more seconds for everyone. That's Scott. It is all yours again. All right. Thank you, everyone.
So we divide the licenses up into two different categories, standard and really non-standard or specially negotiated. When we say standard license, what we're talking about is a license, the full terms of which are spelled out in a data rights clause. So on the DFARS, it would be 252, 227-7013, 7014, or 7015, which address non-commercial technical data, non-commercial computer software, and commercial technical data, respectively. In the FAR, it would be FAR 52.227-14, which is the Rights and Data General Clause, which covers everything except for commercial computer software in the FAR context. But if you were to look at these clauses, they will define internally certain license grants. That's what we mean by a standard license. And there's really 5 different types of standard license. We'll take a look at each of them in turn. On this slide, I just want to talk briefly about sort of where there's differences between the term of art and what it may mean or the types of data deliverables to which they would attach. So at the broadest end of the spectrum, the broadest type of license the government gets, we have what's called unlimited rights. The actual unlimited rights license is expressed slightly differently as between the DoD and civilian agencies in terms of language, but there's little difference in practice. And the same is true for the analogous concept of unrestricted rights, which applies to certain commercial item technical data when dealing with DoD. That just seems to be the term used in the 7015 clause, or what all the other DoD clauses call unlimited rights. Again, slightly different terminology, same bucket of rights. In the middle of the spectrum, we have what are called government purpose rights. As a term of art, that only has a meaning when you're dealing with DoD. There is no such thing as a government purpose rights standard license with a civilian agency. At the narrowest end of the spectrum, the terminology that you use depends on what type of data you're talking about. So if you're talking about technical data, the narrowest license is called a limited rights license. It is called a limited rights license regardless of whether you're dealing with DoD or a civilian agency, but the standard rights that are part of that limited rights license are different depending on whether you're dealing with DoD or a civilian agency. And then on the computer software side, that narrowest license is called a restricted rights license. Again, the same term is used regardless of who you're dealing with, but the actual bundle of rights that comes with it does differ from agency to agency. And then the commercial data rights clause, the 7015 clause, doesn't have any particular name. So we just refer to it as a 7015 B2, or if you're talking about the revisions to the clause in January of this year, a C2 license. That's just a reference to the section of the clause that actually grants the government a license in commercial item technical data. And again, that only is a concept when you're dealing with DoD. Outside of those standard licenses, the DoD data rights clauses also give the government and the contractor the ability to negotiate a non-standard license, a specially negotiated license. It allows you to tailor the government's rights to a particular environment. So you can sort of move away from these prescribed licenses, the standard licenses, and come up with something that satisfies or better meets a particular contracting instance. Next slide, please. So let's take a look at what the rights are that the government actually gets under each of these standard licenses. As I said, the broadest license here is the unlimited rights license. We've labeled it non-commercial, but it is really the same across the board, including for unrestricted rights in commercial item technical data. You can read the breadth of it for yourself, and I think when you do, you will say, hey, that feels an awful lot like ownership. Yes, it does, but it's not ownership. And because it's not ownership, it means you as the contractor still retain the ability to use unlimited rights technical data or unrestricted rights technical data or unlimited rights computer software for your own benefit. Now, it is in fact true that the government can give unlimited rights data to anyone for any reason, including to your competitors to use commercially, but it is a license. They have to exercise it. Granting the government unlimited rights is not the same thing as placing your information in the public domain. So if a competitor on a program with you sees that you've given the government some unlimited rights data, they can't just pick it up and say, well, we get to use it too because the government has unlimited rights. If they want to use it, they need to get the permission to use it from somebody who has the ability to grant them that permission. And there are two parties, at least at the outset. Number one would be you, the contractor who owns the data. Again, you own it. You've not surrendered ownership to the government. And the other would be the government, who have the power through their unlimited rights license to sublicense it to anybody for any reason. But they can't simply take it and run with it. Next slide. In the middle of the spectrum, we have the government purpose rights license. That gives the government the ability to make unlimited use and disclosure of the information within the United States government. And here we're talking about the government as a monolithic entity. So if you grant the government purpose rights under a contract with the Air Force can turn around and give that information to the FBI or to any other arm of the United States government subject to that same license. The government also has the ability to disclose government purpose rights data outside of the government for United States government purposes, which is broadly defined to include any activity in which the government is a party. Most notably, that includes competitive procurement. So the government can take government purpose rights data and put it in sam.gov and give it to offerors on future procurements. What they cannot do is give it to third parties for commercial purposes. As the owner of government purpose rights data, you retain the ability to make exclusive commercial use of that data during what we call the government purpose rights period. That government purpose rights period, by default in the regulation, is 5 years from execution of the contract or exercise of the option that requires the corresponding development. And we'll talk a little bit later about development and how it plays into this concept of license rights. But that 5-year period is negotiable. And I am seeing, and Craig, I'm sure you are as well, more and more solicitations that say, you know what? We will accept government purpose rights in perpetuity. We don't ever need our government purpose rights to sunset out to unlimited rights, which is what they become if you actually do have a fixed time period for government purpose rights. Next slide. On the technical data side, when you're dealing with DoD, the narrowest license is limited rights. Within the government, again, unlimited use, though now we've enclosed it in scaredy quotes, because there is a carve out from that unlimited use, which is the government cannot use limited rights technical data for manufacture of end items. They are also generally prohibited from disclosing it outside of the government, except for some narrow circumstances like emergency repair and overhaul. So you've got a broken down Humvee and you know, for some reason you need to disclose the technical data to some other contractor who happens to be there and can use that technical data to repair it and get the Humvee out of harm's way. So that would be a permitted disclosure of limited rights technical data. To covered government support contractors, that's a defined term in the regulation. I think for purposes today, just understand that it's not your competitors. It's advisory and assistance. It's CETA contractors. It's not somebody who might be your competitor in a future prime contract endeavor relevant to that data. And then maybe soon, maybe not, for segregation and reintegration purposes. This is something you will see in the statute. It was added, I believe, the FY 2012 NDAA, and has still not filtered its way down into the regulation. Who knows? There's a DFARS case pending for it. Who knows when or whether it's actually going to get implemented in the actual regulation. Next slide. The analogous concept for software is restricted rights. I'm not going to bother reading the restricted rights license rights to you. I think what I would point out here is that when you go and you read them for yourself, you will see that these really don't make a lot of sense the way we license software anymore. These regulations, these licenses were written in 1995. Well, actually, they became final in 1995. They were written before that. Back when buying software or licensing software meant getting a pile of disks, 3.5-inch floppy disks in a big box. And if you didn't make a copy of your floppy disk and you accidentally dropped a magnet on it, you were hosed if you ever wanted to reinstall your software. This doesn't have anything to do or really any sort of relevance to cloud-based software as a service or electronically delivered software. It's a bit of an anachronism. Perhaps that will get brought current sometime soon. Next slide. So as I said, limited rights is the term you use for the narrowest rights, regardless of who you're dealing with, but the grant is a little bit different to a civilian agency. The basic grant is the same, unlimited use and disclosure within the government with that carve out for manufacture, and generally no release or disclosure outside of the US government. However, the civilian clause does not have those built-in exceptions. You get to negotiate your own exceptions for additional uses of limited rights technical data when you're dealing with a civilian agency. The other thing to keep in mind is that the limited rights license for DoD is a non-commercial concept. The limited rights license for a civilian agency is all technical data, whether commercial or non-commercial. Next slide. Again, similar concept for restricted computer software on the civilian side, similar implementation. You can see the basic set of rights, and then you can see the last bullet, other rights as agreed. This is actually how you can get to a specially negotiated license when you're dealing with a civilian agency, is by tailoring those other rights in the limited rights or restricted rights grant. Next. And so that brings me to the concept of specially negotiated license rights, which allows you to deviate without requiring a deviation from the standard license rights. Whatever it is that you agree to, you are going to memorialize as part of the contract, and we've seen it as a special contract requirement in Section H. We've also seen it as a separately drafted license that becomes an attachment in Section J. You can do this regardless of the type of acquisition, so commercial or non-commercial. Again, in DoD, civilian agencies, you're doing it backdoor through the limited rights or restricted rights, additional rights. Keep in mind that when you are negotiating, especially negotiated license with DoD, limited rights or restricted rights or commercial rights, depending on what the underlying data are supposed to be the floor for the United States government's rights. In other words, if the government would have a right that came with it as if it were limited rights, they're not supposed to bargain that away as part of a specially negotiated license. That said, my view is that if the government does bargain away a right that it would otherwise have under limited rights, that they are now bound by it. That it is not somehow read out, some sort of reverse Christian doctrine or void ab initio or anything. That is now the contract, if that is what you agree to. Next slide. So let's talk a little bit about the standard allocation of rights, and then Craig will do a little bit of a deeper dive on what development means. But when you're dealing with DoD, the standard license that the government typically gets is going to be determined by the source of development funding. Well, development funding for what? What are we actually interested in the spending of money on? If we're talking about technical data, we're generally talking about the item, component, or process to which the data pertain. We're not talking about who paid to make the tank owner's manual. We're talking about who paid to develop the tank. The only time you would look at the data itself when you're talking about technical data is if there is no corresponding item, component, or process. That is probably going to be the exception rather than the rule. In most cases, you're going to be talking about a thing to which the data pertain. When you're talking about computer software, everything sort of collapses. The data are the software, so you do in fact look at the development funding for the software. Who paid to develop the code or whatever form of software? As Craig said, the definition of software is a lot broader than just the code. So Craig, let me turn it back to you, and you can do a little bit of a deeper dive on development funding. Craig, you're muted.
Sorry about that. There are two buckets, as the slide says. Think of it as private expense and government expense. And private expense, so not government funding, are costs charged to an indirect cost pool. IR&D is most common, but there can be others. Or costs not directly allocated to U.S. government contracts. So particularly for CAS-covered contractors, or if you've got cost reimbursement type contracts, even T&M contracts, you can see where, okay, I know where these dollars went for this kind of work that I was doing. For fixed price or commercial contractors, or those who don't have a lot of experience with the government, understanding, well, was it allocated to U.S. government contract or not? The cost of development, not quite as clear cut. And of course, that word contract, that I'm going to tell you has been defined in the FAR in 2.101 for quite some time. But if you are tracking the revolutionary FAR overhaul, you'll see it's not showing up so far in FAR 2.101. So am I a little nervous about the idea that we may have to hit restart on what is a contract for purposes of this development of private expense calculation? A little bit, but we're not there yet. So we'll see. And until there is a final revolution, I suppose we will continue to operate as though the FAR 2.101 definition applies. And then development and government expense, that's everything else. Now you might say, what about a cooperative agreement? What about a grant? Well, that's why I mentioned the FAR 2.101 definition of contract, which excludes cooperative agreements and grants. So you may often hear the government paid for this. That's not exactly the analysis. And so if you start hearing that, resist the temptation to say, oh yeah, that makes sense to me. Instead, the question is how? Did they pay with a procurement contract? Did they pay with another transaction agreement? Did they pay with a grant or a cooperative agreement? Was there some other funding? And then, of course, those agreements may have their own terms about what rights the government gets. So it not being a contract is not the end of the analysis. The other key point is funding determinations are made at what are called the lowest practical segregable level. And you see some examples there. Where that's probably most important is to think about, we developed some software entirely at private expense, and there's a partition of it that the government paid us to update for US government use. Well, does that give the government some type of GPR or other rights for all of the software because you updated a partition of it at government funding? I mean, it depends is always the answer, but I want you to caution you, like the government paying for part of it through a contract, so it's what's called mixed funding, as you saw earlier, doesn't necessarily mean the government gets it all. And that's where I'll also just remind everyone, as we transition to the next slide, record keeping and how the development was paid for can really pay off in the end. So you see the two buckets and then the blended bucket here, and where under the DoD non-commercial regime do the different rights attach. Now, there are, for example, for unlimited rights, there are some categories we're going to talk about in a moment that are unlimited rights even for items that are developed exclusively at private expense. We'll talk about that in a moment. But this is a pretty handy rubric for thinking about, okay, if I get US government contract dollars, what are my rights likely to be? And that's an important conversation to have when pursuing new programs. You might say, oh, this money from the government would be great. Do we want to then risk that or kind of end up in a scenario where this new product we have or cutting edge product, now the government has government purpose rights in it as opposed to limited or restricted rights? Is that something we want to do? What's the business case for that? And then, as I mentioned, there are some areas or some types of technical data or software where there is automatic unlimited rights. And you can see here, omit data is, I think, an important one, although data necessary for operation, maintenance, installation, and training. Keep in mind, what does necessary mean is a question you should be asking. It's not just data that one uses for operation, maintenance, and installation and training, full stop. It's, do I need this absolutely for this? Scott and I have spent time litigating that question over the years. And then you can see a carve out to a carve out that if it's detailed manufacturing and process data, that's like something to pay attention to. That pulls you back out of this auto unlimited rights. The other ones here, I think, are pretty well, kind of self-explanatory. Although form, fit, and function data, that's another area where defining the edges, you may have some conversations about that. What about commercial technical data? So when the government is, we talk about the government's supposed to act as a commercial buyer and take commercial terms. So that's why the DFAR says the government generally receives only the technical data customarily provided to the public in a commercial sale. There are a few exceptions, no surprise, it's not a fully commercial purchaser. You see form, fit, and function data, repair and maintenance data, and like a commercial buyer, when buying a commercial product or service, the government can bargain for more data, and you should expect that they will. So you might not get all the way to what you might think of as your commercial terms or commercial adjacent, but you may be a lot closer there than when you're dealing with selling non-commercial items. And then the commercial technical data rights, Scott mentioned the clauses and how the customary reference is just to the paragraph number. We've covered those, so we'll move along. And then the civilian agencies. They get four categories of data. There's unlimited rights. Form, fit, and function, you're starting to hear themes. Omit. And this is important. Data first produced in performance of the contract. All other data delivered under the contract. You might be saying, hey, wait, hold on. I've been sitting here for about an hour, and you just told me that there's the deliverable, and then there's the rights. Now you're telling me that data delivered under the contract in the civilian regime might be subject to unlimited rights. Okay, well, that's why, as the middle of the slide says, oftentimes you'll protect limited rights or restricted rights data or software by not delivering it. That's a straightforward way to do it. But, the government buys a lot of software or rights to software and takes delivery. And so there are some alternative clauses in the FAR that allow you to deliver with less than unlimited rights. I'd say it's really important when you see this FAR 52.227.14 clause that you really make sure you pause and say, what are we delivering? what do we have an argument that the government shouldn't take unlimited rights in, and have we negotiated for that? It's not. It's a clause that I find is, especially if you spend a lot of time in DoD and then all of a sudden you're in the FAR world, it's a little bit less comfortable for people, and so it can be easy to say, oh, we've got the FAR clause, we have comparable kinds of rights definitions. Not always the case. And so I urge caution when you start getting into the civilian agency clause. Then there's commercial computer software. So it's computer software that's a commercial product or service. Scott mentioned a moment ago that the way the government buys, just like everyone else buys computer software, has changed to where it seems to live in that liminal space oftentimes of what's a service versus what's a product and what are the clauses that apply to it. But the government typically gets the license or standard commercial license. And there are a couple of exceptions. Maybe it doesn't meet the government's needs, or there are some that are inconsistent with federal law. And you'll often hear kind of the list of EULA terms that you can't have, like automatic renewal, inconsistent with the Anti-Deficiency Act. Indemnity clauses often run into that kind of issue. So all that shrink wrap licenses, shrink wrap terms, or click-through terms that you're kind of used to either imposing or accepting, I think full sheet may not be acceptable, even if, again, when you're selling commercial computer software to the government, you get a lot closer to that. The license is then incorporated into the contract. Typically, it's attached. We've seen cases over the years, disputes cases, claims cases, where the license seems to have never made its way into the contract. You don't want to be in that situation because it doesn't make your life easier. And then there is a fallback commercial license. It's not mandatory for commercial computer software under the FAR. And overbroad, we could spend some more time on this on a longer session. But again, think about, do you want the government defined terms, or are you looking to sell on your terms that you've kind of really meet your market needs? I think I know where I would default to.
And it's actually worth noting, Craig, that clause is gone in the revolutionary FAR overhaul.
Good point. So part two, how the government protects its IP in the federal marketplace. I'm going to talk about one thing very briefly and then hand it back to Scott. You've learned about the rules. You've got kind of your sense of the regime. Well, what do we do with that? And these restrictions, Scott mentioned the Christian doctrine, the idea in government contracting that some clauses are read into the contract. Well, there's no comparable self-executing, I've got these rights, therefore they are protected. I can sit back and just let my business deliver without anything more. It's important to understand, this is really one of the most prescriptive process, here's what the rule says exactly, you need to follow the rule parts of government contracting, which I think is saying something for as process and prescriptive as government contracting can feel. But they call it the data rights trinity. I really love that term. It's three things, and we've touched on them to varying degrees. One is documenting, and the second is asserting your rights, and the third is marking. I'm going to talk briefly about documentation, and then Scott will talk about assertions and markings. With documentation, it is, I keep saying this because it is difficult to do in practice, but the idea of, particularly for DoD contracts, keeping track of when the item to which technical data pertains, how the funding for that development was tracked, or for computer software, the funding for development. It's not easy to do in a way that makes sense when lawyers and a judge are trying to puzzle through, well, when was this software developed? A lot of software versioning systems or software development systems, it's sort of like when I have to deal with prevailing wages for government contracts. Payroll systems aren't set up for that. And so understanding what are the risks of us perhaps not being able to show we developed an item or we developed software at private expense in the future, and how much is it going to cost us to mitigate that risk is an important early consideration or conversation to be having. Those records could be, as I mentioned, software records. You've got accounting record for the cost, could be engineering for technical data. There might be other appropriate contemporaneous records. And then the other hard part is keeping the records once you've made them. So you could have great records, but if they're from 1997, and I think in some of our cases, that's relatively new record keeping, that you have them and you know where they are, and they're on a server that doesn't get wiped when the server has run its useful life. So it's making the records or the documentation and then keeping the records and the documentation. So Scott?
Thanks, Craig. So the last two parts of the Trinity are assert and mark. And assert is a thing that happens during proposal preparation. This is how you signal to the government that as part of contract performance, you, government, are going to receive certain elements of data with less than unlimited rights. And the FAR and the DFAR, Civilian Agency, DoD, do this slightly differently. The FAR uses a representation approach where you essentially tell the government either nothing is going to go with less than unlimited rights, or some things are going to go with less than unlimited rights, and here's what they are. And that is really a signal to the government that they should be adding the appropriate alternate clauses to allow you to deliver technical data and computer software with less than unlimited rights. As Craig pointed out, everything you deliver to a civilian agency under the standard clause, whether it satisfies the definition of limited rights technical data or restricted computer software or not, goes with unlimited rights unless the alternate is in the contract. And so this is your signal to the government that, hey, you need to put the alternate on there. The DFAR's standard is to use a table approach, and we'll look on the next slide at what the format of that table is. I will say I am seeing, as I said, Craig, I'm sure you are as well, more and more solicitations, whether you're dealing with a civilian agency or a DoD activity, that require an assertions table that is far more involved, far more robust than what the regulations, what the FAR or the DFARs would prescribe as a starting point. And that's neither right nor wrong. I think the key takeaway here is whatever it formatted the solicitation tells you to follow it. And that goes for assertions as to commercial technical data or commercial computer software as well. Generally speaking, when the government contracts commercially, they behave like any other commercial buyer. And when I show up at Best Buy and I buy something, I don't say, where's your assertions table for the rights that I'm getting? I just walk out the door with it. And so you could reasonably expect that if the government is buying commercially, that they should not be asking for an assertions table. And indeed, the DFARS does not include an assertions table requirement on the commercial side. But it is not wrong to include your commercial assertions in a table. It sort of puts the marker down that you are asserting that there are certain elements in which the government will have less than unlimited rights in the form of commercial data rights. And as I said, more and more solicitations are going well beyond what the minimum standard would be in terms of an assertions table. So big takeaway, whatever the solicitation tells you to do when it comes to assert, do it. Next slide. This is what the standard DFARS assertions table looks like. And if we go to the next slide, give you a little bit of an overview on how we generally suggest to our clients that they fill it out. So it really is sort of just a narrowing funnel of what ends up in that table. And where that funnel starts is to review the entire solicitation, not just the procedurals, not just the SAO, everything, and identify all data elements, all technical data, all computer software that you are going to have to deliver to the government as an element of contract performance. And do that from the standpoint of what do you know, or what should you reasonably know from reviewing the entire solicitation. And that reasonably should know standard is important, because if you forget something, you want to be able to go to the contracting officer when you say, hey, I need to update my assertions table. And the reason that the element I want to add to the assertions table is missing is because nobody in their right mind would have understood it to be a deliverable from reading the solicitation. It was completely unknowable and not reasonably knowable. If it was something that was right there in the solicitation and you missed it, or something that was a reasonable inference from what was in the solicitation, you're a little bit more throwing yourself on the mercy of the contracting officer. And that's not always a good place to be. The next step in that funnel, now that you have the list of everything you're going to give them, is to identify everything that you have a legal justification to restrict. So it was developed exclusively at private expense, or it is commercial and presumed to have been developed exclusively at private expense. So you identify all of those. Then you identify what you actually are going to deliver with less than unlimited rights. Just because you can restrict the government's use and disclosure of something does not mean that you are going to do that. You can actually offer the government broader rights, and you may wish to do that for certain strategic reasons. So now you've narrowed your funnel even further. You've gotten down to the list of things where you have a legal justification for restriction, and you've made the business or strategic decision that you are in fact going to restrict it. And then the question is, does it go in the table? Right? And again, follow whatever the instructions are in the solicitation for what goes in the table. Basic table, just your non-commercial technical data and computer software, nothing else. And then that allows you to complete the table from there once you've got all your different line items. Next slide. Marking is the last piece of the data rights trinity, and this is what happens during contract performance. So the assertions tell the government, hey, you're going to get something with less than unlimited rights. Marking is, hey, government, here's the thing you're getting with less than unlimited rights. And the rule here is follow the instructions in the data rights clause. It will tell you what words to use, and it will tell you where to put those words. Do not get creative. Do not deviate. Do not use short forms unless the contract tells you can use short forms. And as Craig said, this may end up looking like a NASCAR stock car. You may find yourself putting so many markings onto a piece of data that you're delivering that you wonder where the actual content goes. Don't try to shortchange the markings and just give the content, or don't try to shortchange the markings in order to fit more content. Condense your content, move it to other pages, whatever it is you need to do, because the consequence for failing to follow the rules on marking is, or could very well end up being, that you are granting the government unlimited rights in the content. Right? There's a process by which you get there. The only time you sort of immediately go there is if you fail to mark entirely. If you put a marking on it of any sort, even if it says proprietary, I would consider that a speed bump. And the government is going to tell you that's a non-conforming marking. What do you mean proprietary? That's not a legend that's prescribed or that is authorized by the regulations. So go fix it. But the end game of that go fix it process, if you don't actually, in fact, go fix it, is they get to ignore the marking. And if they ignore that marking, we're back in that unlimited rights situation. If we go to the next slide, you can see what I mean and what Craig means when we say these are not trivial. These markings go on every page. This is not just something that gets stuck on the cover page. Any page that contains government purpose rights or limited rights or special license rights information gets this attached to it. If a page has more than one form of information, multiple legends will be attached to it. So you can see where this gets or can get a little bit, I don't know, maybe out of hand or maybe complicated, cluttered, or busy is the best way to say it. So that's everything that we wanted to cover
hey, Scott,
today.
Before we move on.
Oh, yeah, absolutely.
Some of our audience may be wondering where the unlimited rights marking is.
There is no such thing. At least not yet. So, unlimited rights is a thing that happens when you don't put a restrictive marking on. After the Boeing Federal Circuit decision, the end of, I think, what was it, 21? It was back in the pandemic. It was back then. The government, the DoD, did try to promulgate a rule that would require an unlimited rights marking. They tried to shoehorn that into the updated clause for the Small Business Innovation and Research Program, which was implementing SBA action from 2019. The SBA part of it was non-controversial. Trying to reverse the Federal Circuit through a regulation was very controversial. And so that has been pulled. The SBA part of it has been reissued. As I said, January of this year. We are told the rest of it is still kicking around out there. But again, like any other regulation right now, who knows? So Josh, if you want to do the second password, I will take a look at the question that popped up.
just kind of mention that I put it into the chat for you both. So we do have one final password, and we're gonna have a final poll after that password, and that poll is gonna be a little different than it usually is, but I have kind of multiple parts there. Our final password is up now, and that is hackers, capital PACKERS, which you might have guessed if you were up a little too late last night watching one of the highest scoring overtime games. Our final password is hackers. I'll leave that up for just a few more seconds. And I'm going to put up this next poll. In addition to that, I want to thank you all for joining us today. Sorry about that kind of mishap with the link. I'm glad you all were able to join us today. Scott and Craig, I want to thank you for the last 75 minutes of instruction. And before you do get to that question, Scott, I'm just going to put up this final poll. This is going to be the ratings poll and the poll that you'll usually see when you leave, whenever we host usually like a GoToWebinar. So that has the what other programs you want to see and stuff like that. I'll put that up now. And then Scott, Craig, it is all yours.
Yeah, so the question we got is under the upcoming FAR overhaul, clause 5227-19, commercial computer software licenses being removed. What are the impacts? From industry's perspective, I would say the impacts are only positive. As Craig was saying, the 227-19 clause is not great as as compared to a well-drafted end user license agreement for commercial computer software. So, I mean, the answer is going to be there's not going to be any shortcut. You are going to have to come up with a commercial software license, but our recommendation has always been you should do that anyway.
It's gonna make negotiating those subcontract flow downs easier.
Yeah.
One less thing to kind of go back and forth on. All right, well, I think that's our only question, Josh.
That is all I see right now. Let me just check the chat one more time in Q&A. I don't have anything else here, so I thank you all for joining us today.
Okay. Thanks, everyone.
All right,
Okay,
thanks,
all
everyone.
things in the
Take
chat
care.
I saw things in the chat, but it's just thank yous for the two of you. So thank you again. Hope you all have a great rest of your day.
Take care, everyone.